If it pleases the court, my name is Frederickson Maboko. I am leading counsel for the plaintiffs. And today I am with my co-counsel, Ms. Mariam Issa. We're here today in this issue between the plaintiffs and the defendants. I would like to bring the bench, I would like to bring to the attention of the bench that there are 6 issues here before us today. 2 issues were raised by the defendants as the preliminary objections, and the other 4 issues shall be based on the merits of the case. My co-counsel and I shall address the merits and the preliminary objections. I will address the preliminary objections and the first merit issue, and my co-counsel will address the remaining merits. If the court allows me, I would like to proceed.
Easy.
Thank you. Before I begin, I would like to avail this honorable bench of the facts that have led us to this dispute here today. Our clients, the plaintiffs, have been in business in the country of Gatronia for more than 30 years. This arises out of an investment agreement that was entered into in the year 1980. We have been in business for 30 years, and as it is always the case, business is not always booming and business struggles, but we have been here for 30 years with the people of Gatronia.
Stop you for a minute. Can I just check that counsel can be heard on the microphone? Yes?
Thank you. We have been in business for 30 years. Our clients have been in business for 30 years in the country of Gatronia as an investor. And under the investment agreement that was initially entered into, we have enjoyed certain rights and had certain obligations towards the government of Gatronia, who was the other party in this agreement. Due to recent events, my clients' rights under the contract have been threatened, and it has made business even more difficult for my client. Hence, this dispute that has been brought before this court today. That having availed the honorable bench of the facts of this case, may I proceed to address the preliminary objections?
You may.
Thank you. The first preliminary objection discusses the issue of admissibility of this case before the court and the jurisdiction of this court to entertain this suit. I would like to submit before this honorable bench that I would like to begin my submission before this honorable bench by stating that the jurisdiction of the High Court Commercial Division of Gatronia as far as commercial matters are concerned is unlimited. This is provided under Rule 5 of the High Court Commercial Division procedural rules. Further, I would like to avail the bench of the fact that the plaintiffs are aware that there has been, in fact, an arbitration agreement which was incorporated into the legal pact under Article 12 of the pact. However, my lords, as the facts have stated, there has been an unwillingness, a total unwillingness of the defendants to engage in this arbitration clause. Specifically, my lord and my ladies, I would like to direct you to paragraph 22 of the facts. Paragraph 22 of the facts states that when the notice of arbitration was served by the tribunal, the country of Guatemala refused the notice. That being the case, my clients, the plaintiffs, have decided to bring this matter before you in this honorable court today, so that we may be served the justice that we were denied in the previous arbitration proceedings.
If I may, can you explain to me what the governing law of the contract is? This is the contract under those laws.
My lady, if I may speak, if I may answer your question, the governing law of the contract, as a matter of practice, as a matter of law, is directly connected to the dispute resolution clause and various clauses. The moment that the other party to this contract, which is the government of Guatemala, rejected our arbitration proceedings and violated this contract, my ladies, as we shall so forward prove as my co-counsel proceeds, the binding effect of Article 13, which states the governing law of the contract, we have brought this court because the binding effect also left with the validity of the agreement that they have violated.
Okay. Counsel, what other legal remedies are available in case a party unilaterally disagrees to observe the arbitration clause?
If I may answer your question, under our arbitration clause incorporates the ICSID rules, as the pact has stated. Under the ICSID rules, specifically Article 45, sub 2, if my memory serves, states that if a party fails to appear, then the proceedings can go on with a single party, and the award may be given and enforced.
And in light of that provision, why then did you not report the ex-party proceedings instead of bringing them to this court?
If you may allow me to speak, my lady, Honorable Judge, I would like to answer this question by stating that it has been given clearly by the facts of this case that there was never an intention for the government to come to arbitration. It is seen that there have been various, if reading from paragraph 20, 21, and 22, there have been multiple attempts at communication with the government of Guatemala, and they have not responded. When we communicated through ICSID, they also did not respond. Our client is a business that employs and loses money every single day as the agreement is not upheld. Hence, we are here today to ensure that our client can get justice in one way or the other. And we hope this court can be the way we do get this justice, my lady.
Counsel, what you're trying to establish is that, are you trying to say that there are no any other remedies under the ICSID rules that you could have approached?
No, my lord, that is not what I intended to say.
Then what other remedies are available under the ICSID rules?
If my lord would allow me to refresh my memory on that and get back to you at a future time. Thank you. As I have stated, my lords, if I may continue, the government has had no intention, and the arbitration clause, due to the government's lack of cooperation, has become inoperable due to the government's inaction, and hence we are here today to get justice before this court. If the court allows me, I may proceed with the second issue of the preliminary objections. Thank you. With the second issue that was brought as a preliminary objection regards the locus standi of the second plaintiff. The second plaintiff, who is named Lejonzi Mining Company G Limited. The facts in the record clearly state that Lejonzi, the second plaintiff, is a subsidiary of the first plaintiff. And and the requirement for locus standi, as it has been established in the courts of Gatronia, was established as it was established in the courts of Gatronia in the case of Lujuna Shubi Balonzi, Senior, versus the registered trustees of Chama cha Mapinduzi, stated that for a person to have locus standi, their rights must be directly affected by the dispute in question. My lords, it is the plaintiff's submission that the second plaintiff is affected directly by the breaches that have been committed against the first plaintiff as well.
So just explain to me then, what's the point of sanctity of contract and the lack of third-party rights in our jurisdiction?
Thank you, my lady. May I respond? The doctrine of sanctity of contract is a sacred doctrine in law, and we do not in any way challenge it. And the doctrine of sanctity binds parties to the agreement that they have consented to. That is its position in our law.
Okay. And privity of contract?
Privity of contract prevents a person who is not party to an agreement from claiming from that agreement.
Is your second plaintiff a party to this agreement?
If I may address the court, my lords, the second plaintiff is not a party to this agreement, but is directly affected by the actions that arise of this agreement, if I may avail you to certain facts. If I may direct the court to paragraph 13 of the practical case, it states that the parties, that there shall be a mining operation, there shall be a company, that there shall be a business that operates in the Republic of Gatronia on behalf of the party in the contract. This is stated in paragraph 13 of the practical case. Also, reading from Article 6 of the Lilo Pact itself. May I proceed? Article 6 of the Lilo Pact itself. Though there is no explicit mention of the name of the company, there is a reference to a company that carries the 16% free, the 16% free carried interest of the government. And this company is none other than the second plaintiff, my lords.
Read me that paragraph.
If I may get my case file.
Okay, so because this says, I can read it to you, the government shall have a 16% free carried interest rate from the investors' mining undertakings and receive a commensurate proportion of profit in the event of dividends are declared in territory. So is that a reference to a company?
It is, my lady, if I may respond, this is not a reference. The reference is, as I stated, the reference is implied in the statements of the facts. Though they have not mentioned the name of the particular company, if we move further with the facts, we see that the company, this company is the one that was, this company eventually is the one, the second plaintiff is eventually the company that is vested with the mining land that mining is done upon in this operation.
So if the parties don't have to suffer loss, if you have to suffer loss to be a party to this tableau case, what loss has the first company suffered?
The first company has been the 400, my lady, if I may direct you, specifically to paragraph 21 of this practical case. It states that President Raven undertook to return over 300 acres of ill-acquired land. This land was the land that had been vested under the subsidiary that is mentioned under the company mentioned in paragraph 16.
What loss has the parent company suffered? Please explain that to me.
My lady,
Subsidiary and the parent.
yes, my lady, the parent company, which is the first plaintiff, the first plaintiff has suffered a loss, as directed under paragraph 20, of more than $400 million, and its stock price has plummeted to zero in the Ndanzi Stock Exchange.
How? The subsidiary suffering a loss.
My lady, the plaintiff's submission here today is that both the parent and the subsidiary are suffering losses, and hence their presence in this court.
Okay, what's the definition of a subsidiary?
A subsidiary is a company that is owned under, a subsidiary is defined under section 487 of the Companies Act. It can mean a company who more than half of the nominal equity is owned by another company, or there is a controlling, another company controls its board of directors, if I may paraphrase. My lady, if I may answer your question. As I stated in my introduction, that business business has not been good. What I meant to say is that there has been loss, but my client remains in this business because as far as my client remains in this business, it means that they believe that there is a projection to get to profit at some point. It might be due to the nature of mining and investment. Profit might not be something that materializes today or tomorrow, but it will certainly materialize. But with the actions the government of Doctrine is taking, there will be no path to profit for this company. Thank you, Honorable Judge. So, with regards to the issue of local standing, my lords and my ladies, I would like to state that I would like to state before the bench that both companies are suffering loss, and hence the second plaintiff for the losses suffered and their interest being directly affected has local standing in this particular suit.
Thank you. Can I ask why you keep addressing us my lord and my ladies? Should men come before women?
No.
When I'm the Lord Justice in this court.
I apologize, my lady.
Thank you.
I would like your guidance on how I should address the bench collectively.
My ladyships and my lord.
Okay, thank you. Once again, I apologize. With regards to the preliminary objections, my ladies and my lord, I would like to now submit my prayers. It is the plaintiff's prayer that this court finds that this suit is admissible and it has the good jurisdiction to hear this matter. It is our second prayer is that we pray that this court finds that the second plaintiff also has the local standing to remain in this suit. That being the case, may I proceed on to the merits of this case?
You may, unless questions.
As I stated before, I shall be presenting on the first merit issue. The first merit issue refers to the acts. The question asks whether the acts of the President of Doctrine has breached the Lilo Pact or the investment agreement, as we refer to it here today. My ladies and my lord, I would like to bring to the attention of the bench, that the president's actions. I would like to submit to the bench that the president's actions have in fact breached the agreements, and there have been various actions which we shall identify one by one for the bench to see. If there is no question, I will proceed with this. The first act that the President of Doctrine has committed that has breached this agreement was the appropriation of land. If I may direct the bench to paragraph 21 of the practical case, it states that the President chose to appropriate land that had been used for mining. Specifically, the President took all the mining, left the second plaintiff with only land that has been exhausted of mines. Practically speaking, our company right now, our client has no mines to mine. There is no business for our client. This is a breach of Article 2 of the Lilo Pact, which requires for the government to provide favorable conditions for the survival and existence of the agreement and the investor. By taking away the mines that are the core business of this company, there can be no business, and the existence and survival of our clients is challenged and threatened. There can be no business in this.
So does the fact then that there is no land mean the company no longer exists?
No, my lady, that is not the fact.
Oh, okay. So where is the bottom? Where is you draw a line on existence and survival?
My lady. Okay, if I may elaborate on that point. When I mean the existence and survival of the company, as I stated, this is a business and it is an investment that is projected to continue for a long time. Our existence is threatened when the core business that generates income is taken away. The core asset that allows us to generate income is taken away. That means the projections that allowed us to say that we might one day achieve profit will now certainly say that we will never achieve anything. the company's value has, as I have previously stated, under paragraph 20, has already gone to zero on the stock exchange. The existence of this company is threatened, my lady. As for the second act, hence, by appropriating the land, the President has directly breached Article 2 of the Lilo Pact. Further, I would like to submit before this bench that as per Article 4 of the, I would like to submit that the second issue of breach that the President has committed is signing the laws and signing and trying to enforce laws contrary to the Stabilization Clause that we had in our agreement. If I may direct the court to Article 10 of the Lilo Pact, this article is a Stabilization Clause that freezes the legal regime that governs this agreement for the continued life of the agreement. It is a clause that lives throughout the agreement. This clause assured our client, the investor, that the plaintiffs, that there would always be the legal regime governing our agreement would not change. Hence, the government would not try to execute any laws to apply any laws onto us that would affect this Stabilization Clause.
So just to check, are you addressing the point of the Stabilization Clause now, or are you addressing it later? Because you have a separate submission on the Stabilization Clause.
My lady, I am addressing, if I may clarify, I am addressing the specific acts that the President has done that breach the agreement.
We're going from the Stabilization Clause then, if you're going to be addressing it later?
The other matters regarding the Stabilization Clause will be addressed by my client.
Okay.
Thank you. So, if I may further direct the court to specifically Article 10.
Did you say your client is addressing points?
Sorry, my co-counsel.
Okay.
I apologize. That was a slip of the tongue. Specifically, may I direct the court to Article 10, Subarticle 2 of the Lilo Pact. This article specifically states that any forceful change of the regime amounts to a fundamental breach of the agreement made.
We're still on the Stabilization Clause here, Counsel.
Oh.
You're directing me back to the Stabilization Clause. Are you going to address this point now, or is your co-counsel?
No, my co-counsel will.
Okay, please move on.
Very well. The other act of breach that has been done by the President of Doctrine that I will wish to avail the bench of is stated under paragraph 20 and paragraph 20, 21, and 22 of the practical case. The President has refused to communicate or hence engage in mediation, and has refused to arbitrate on the matter that regards this dispute. Article 12, which is our arbitration clause, our mediation and arbitration clause, requires that whenever a dispute arises, we be allowed to go to mediation. That will be followed by arbitration further ahead if it fails. However, the government of Doctrine and the President has not responded to our communications, and they have not responded to the notice of arbitration that we have served before them. This act is a clear breach of the agreement that we had signed and they had chosen to be bound by.
Counsel, I take you back to the initial question I asked, that the respondent state has not responded to your call for mediation, has not responded for talks with you. In the event that the other party is unresponsive, and you had clear provisions regarding dispute resolution under your contract, and to quote your very own words, that there is sanctity of the contract. On your part, what recourse should you have taken, or what other avenues were available to you under the arbitration laws that you had agreed further
If I may answer, my lord, as I stated before, I would like to refresh and avail the court of this matter at a later time. However, if I may add that in regards to sanctity of the contract, we do agree that this contract is protected, and the doctrine of sanctity of contract also carries with it obligations for the parties to act on the things that they promise to do. Hence, by not fulfilling their promise, of coming to arbitration as it was agreed, we have also chosen to come here today because we can no longer rely on the sanctity of a contract that has already been violated. And
Counsel, if I may rephrase the question, because what we want to find out is why did you not explore the ex parte proceedings? In that way, haven't you also breached the terms of the contract by not exploring the unilateral ex parte proceedings which you were supposed to before approaching this bench?
In a manner of speaking, my lady, yes. In a manner of speaking, my lady, yes, we have not yet explored those proceedings. But our client, as I have spoken before, that our client is a business, and the government has already not responded, and we needed to get their attention and to get them to react to something that we would do, so it would be on a platform where we could speak to them. This is the only platform that was available for us. So although we have not exhausted everything that we could have done before the ICSID, however, this matter is of urgency to our client, hence the instruction to bring us here today before this honorable court.
Counsel, the respondent state through the President's statement, they have enacted a law, the Unquestionable Terms Act. They have stated that all other agreements that are currently in place in Doctrine will be under review. Don't you think perhaps it is premature to have this, for us to discuss the merits of the case before you have not renegotiated with the respondent state?
My Lord, thank you for the question. If I may respond. My Lord, I agree that I agree that there is. I am aware of the new law that has been passed by the National Assembly, and though it may seem premature to come before this court, I wish to also remind the court that the opposing side, the government, has not been in communication with us whatsoever. At this point in time, our client is in a state of unknown. We have only come here today so that we may be certain that renegotiations will be opened, if at all.
So you're acknowledging that the Untouchable Terms Act applies?
Sorry, my lady, I did not state that. I acknowledge that it exists, but due to the existence of a stabilization clause, it cannot be applied to this particular agreement.
Just take a back a step.
Yes.
I understand your arguments that okay, so your time's actually up?
Yes.
Yes?
May the court allow me a few seconds to summarize?
So I will allow you 5 minutes, including an answer to this one question. So take me back to what you're actually ultimately pleading, because there's a lot of information here, and I understand you're saying there was a breach of the contract. What do you want? Because the breach of the contract, I understand, provides for various things.
Yes.
What are you actually asking for as a result of this alleged breach?
As a result of this alleged breach, which I have directed, has been conducted by the President for violating Article 2 and Article 12 of the Legal Pact, we pray that this court finds that the President has breached and we be granted any remedies that the court finds legally available for us.
It's not up for us to say what remedies are available.
Yes, my lady.
It's for you to plead them. So what will you be pleading or praying for?
If you may allow me to refresh my memory.
Just from a practical perspective, what do you think your client wants?
My client would like, if possible, to open via Article 9 of the Legal Pact discussions on variations of the terms of the contract so the investment agreement can continue to operate in a reasonable way.
And you're going to do that in negotiation on what basis? If you don't agree terms, what happens?
It is our submission that if they return to the contract and uphold it, and there is a dispute that arises, then we will, and there is a conflict regarding what are the terms that are fair, we will go back to the dispute resolution clause, Article 12, and resolve that dispute accordingly, as per the contract. Our only wish for our entire cause, my lady, if I may state, rests on the protection of the Legal Pact. It is what we're here today to protect.
So you'll go back to arbitration. So you've come to us today, but you will go back to arbitration.
If they uphold the contract. My lady.
Please carry on with your conclusion and your first.
Yes. My lady, as I pray that this court finds that the president of the Atronia has breached the Lilo Pact and I would like to allow my co-counsel to continue with the remaining merits.
Good afternoon, my ladyships, my lord. My name is Mariam Issa, as my co-counsel earlier introduced me, and I'm here to address the remaining merits issue of this case. The first issue that I will address is whether the president can invoke the doctrines of public trust and parens patriae to stagnate ongoing activities, mining activities. We do agree that the president can invoke in public trust because sorry, my ladyship, the doctrines of public trust, specifically the doctrine of public trust, provides that the or is a of the president is in a fiduciary relationship with the citizens, and he or she acts as the trustee of the natural resources of that land.
What's the authority of the doctrine of public trust?
My lady, I would like to refresh my memory on that and get back to you. If I would like to address also the doctrine of parens patriae, as you asked. And the doctrine of parens patriae means that the president acts as the parent of that state, and therefore he is or she is the caretaker and is has the obligation to safeguard resources of that land.
Where's the authority for that doctrine?
I currently do not have the authority, my lady.
Is it statute or case law?
It will be case law.
Both of them?
Yes,
Case law.
yes.
Okay.
My lady, we do agree that the president can invoke these doctrines. However, and we do agree that this doctrine can be invoked, especially where a country is arguing that they're invoking it for public interest, as I have said. However, from the record and the facts of this case, the president has decided to acquire land that was lawfully given to my client for mining activities. However, we do agree that they can do. Sorry?
Under what authority do you acquire the land?
Under the Land Acquisition Act.
Okay. Does
Yes.
he have a right to acquire land under the Land Acquisition?
Yes, my lady, the president has the right to acquire land under the Land Acquisition Act, specifically in Section 3 and 4 of the Land Acquisition Act of Gatronia, and this is for public interest. However, public interest should be accompanied with compensation. But from the facts of the case, there has not been compensation to my client for acquiring the land. And this is what we are here to submit here today.
And which
That
client's land was acquired? Because you have two clients, you have two plaintiffs.
the subsidiary, my lady. Furthermore, on this issue, we are here to plead that even though they...
Sorry.
Sorry.
So there was no compensation at all?
There was no
This is
compensation.
when the land was taken away?
Yes, my lady.
Okay, what should the compensation have been?
Well, I cannot, my lady, I cannot exactly state what the compensation would be. Either the compensation would be either to give a new land to my client, or to compensate them in means of monetary means.
Okay.
How?
This was mining. Why are we talking about land?
Well, the land is the subject matter of this agreement.
So under Australian law, my understanding is that a mining license is what is needed to do mining, regardless of whether the entity owns the land.
My lady,
So what's happened with the mining license?
My lady, I cannot answer this question right now, but I will in the course of my submission.
I think we should check the facts on that point. Okay.
May I proceed?
Counsel, sorry.
Yes.
Separate from what the lead judge just asked, why should you be compensated when the land has been or still acquired?
Well, my lord,
If the land has been
if the land was ill acquired,
it is alleged,
Yes.
part of the compromise,
yes,
it is alleged that the land that has been expropriated from the court was ill acquired. So
Yes.
why should there be compensation for something that is allegedly was not even given yours to begin with?
My lord, I would like to answer your question as follows. The land that was given to my client, the facts do say that the land was ill acquired, and if you do find so that there was ill acquired, however, this does not remove or degrade the obligation of the government to give compensation, especially because the land is the subject matter of this contract, and my client is depending on this land to be able to make profit under this agreement. May I proceed?
So just go on the same point. So I do understand the history of our great country. There have been many years of people really suffering before that land was allegedly ill-acquired
Yes.
by this mining company and its parent company. What I want to understand is, you said the Land Acquisition Act requires compensation. Are there any other sources of compensation? Are there any other laws that would require compensation in this circumstance?
Yes, my lady. The other law that requires compensation is per Article 24 of the Constitution of Gatronia, that provides that where private property has been acquired by a state, the state has the obligation to compensate that, to compensate the party.
Any other laws?
Section 11 also, my lady, Section 11 of the Land Acquisition Act provides that compensation to be granted where land has been appropriated.
Any others?
I don't have another law, but I do have a case law, maybe,
Okay.
if you would like to.
We can look at your written submissions on the case law on that.
Oh, so may I proceed then?
You may go.
Thank you. Furthermore, my ladyships and my lord, even though the defendants may argue that they're appropriating this land for public purpose, let me remind the bench that this is an international investment agreement between my client and the defendants. And it is required under international law that where a government decides to repudiate from an investment agreement,
Sorry, apologies. How is this an investment agreement, an international investment agreement? Your co-counsel told us earlier that it is governed by a particular state's law. So how is this an international investment agreement?
My lady, this is an international investment agreement because the plaintiff's company, my client's company was incorporated in another country, and therefore, and when they entered into this agreement with Gatronia, similarly it means that the government of Isle of Ndanzi and the government of Gatronia have entered into a treaty.
But your client's a company.
Counsel, can you clarify, is this a treaty or a contract?
It is a contract, my lady. Yes.
Your client's a company. Your client is not foreign countries.
Yes, it is not a foreign country, my lady. However, because their company has been incorporated in another country, then therefore this would be an international investment agreement between the two.
Under which law?
I do not have the law at the moment, my lady.
Is there a separate multilateral or bilateral investment agreements in place with these countries?
With these two countries, not from the records, my lady. Yes. May I proceed? Furthermore, on this issue, where a country decides to appropriate land or any subject matter of an investment agreement, they should provide, the requirement is that it should be for public interest. However, one important element or requirement for expropriation or appropriation of a subject matter to be lawful is that there should be compensation, as I said, but also there should also be due process of the law. The government of Gatronia was to observe due process of the law when appropriating this land.
Council, can you
Yes.
kindly guide this court on the due process that the government of Gatronia was supposed to follow in this regard?
Thank you, my lady. I will answer your question as follows. The due process of the law, my lady, entails that the plaintiff or any party that is being challenged should be given the right to be heard, and their case to also be reviewed by a tribunal that is fair, and also that their case should also be heard, like I said. And this was not afforded to my client by the government of Gatronia. May I proceed? I would like to refer the case before the ICJ, the International Court of Justice, and this case is by the name of Electronica Sicila SPA versus United States of America, where it was stated that.
Counsel, before you proceed, of
Yes.
what value is the authority from the ICJ in this court?
My lady, this case serves as a way of persuading this bench to consider this point. Yes. If I would proceed, I would like to mention what was written, as at least even quoted from this case, is that a willful disregard of due process of the law is an act which shocks or at least surprises a sense of juridical propriety. And from the facts of the case, as Section 21, sorry.
Sounds like a moral judgment more than a legal principle.
Sorry?
Sounds like a moral judgment more than a legal principle. I don't understand the principle behind what you just said.
Well, the principle says that disregard of the due process of the law will be an act that goes arbitrary to juridical propriety. And juridically, there's a process, there are procedural requirements for a person to institute a case and also afford the other person to also have their case to be heard in any tribunal or any forum.
So what's the proper forum when a regulator in our country misacts?
Sorry, my
When a
lady?
regulator or government
Yes.
inappropriately acts on something, what's the proper forum in this country?
The proper forum where the government,
For you to have that tribunal that you just referred to,
well,
fair chance to speak.
well, the party that is aggrieved would have to would have to file a suit in front of, in a court that has competent jurisdiction.
So what does it say in the Land Acquisition Act as to that? Is there a requirement in the Land Acquisition Act for that fair tribunal?
For the moment, my lady, I do not have the correct reference to that.
Okay.
May I please proceed? Furthermore, on the issue of parents patriae, my ladyships and my lord, invoking parents patriae and public trust doctrine would be an indirect expropriation, like I said, and by the acts of President of Gatronia, the acts of President of Gatronia satisfy the definition of indirect expropriation. And if I would proceed to another point under this issue, is that invoking the doctrines of public trust and parents patriae will be a violation of the principle of fair and equitable treatment standard, which is under international investment law.
International what, sorry?
International investment law.
Okay.
Yes.
Specific law?
A specific law?
Is it a specific law?
No, it's a standard.
Okay.
Yes.
Can you kindly guide the court in a few of these general standards of treatment?
My lady, I do not recall all of the standards, but
The
specific.
ones that are relevant to this particular case.
Oh, the ones that are relevant to this particular case specifically is the fair and equitable treatment standard.
Rather, what I'm asking is how can a country demonstrate fair and equitable
That is what I was going to address, my lady. And a country can observe fair and equitable interests where they are abiding to the obligations that they have entered into when they have entered into a contract or an agreement with a foreign investor. And in this case, my client, the president of Gatronia, and the government of Gatronia, the defendants, have not complied with this standard as required under international investment law. If you, I would like to proceed saying that the defendants have breached this standard because they have violated the legitimate expectations that my client have. And the legitimate expectation that my client has is that they will be able to flourish and make profit out of this agreement. I would like to proceed to the next issue, my ladyships and my lord. The next issue in this case is whether the newly enacted laws are applicable to the Lilo Mining Pact, considering existence of the Stabilization Clause under Article 10. I would like to direct the court to Article 10 of the agreement. And the Article 10 of the agreement incorporates a Stabilization Clause, stating that no changes in law or policies or subsidiary law will affect the agreement after it has been concluded. However, by enacting the new laws, the defendants will be in breach of the Stabilization Clause. My ladyships and my lord.
What does the stability of this agreement mean? What does this mean, just in basic language?
Sorry, my lady?
That the agreement will be stable during its lifetime. What is stability? What does that mean?
It means that the laws that were used to apply, the laws that were used when entering into these contracts will be the only laws that will be used and not any future laws enacted by the government.
Okay.
Yes. May I proceed?
Yes, so just take me that slightly more. So for example, tomorrow if a new permit was required for something, you wouldn't have to get that permit.
Sorry?
Tomorrow, if a new permit was required for something, we're saying you wouldn't have to get that permit.
A new permit?
If the tax rates went down, they wouldn't apply to you.
My lord, my ladyship.
The law in the country cannot change as regards this country.
My ladyship, I would like to answer as follows: that we're here dealing the question of stabilization clause is a substantive matter, but we're acknowledging that under Section 14 of the Interpretation of Laws Act says that no law can act retrospectively. However, if a requirement is a procedural requirement, then that law will act retrospectively.
Okay.
Yes, my ladyship.
Counsel, what is a stabilization clause?
A stabilization clause, my lord, is a clause that acts, or the role of a stabilization clause in an investment agreement is to make sure that no further laws that will be enacted by a government would be used to interpret that agreement or be used against that agreement.
Are you sure that stabilization clauses seize all other legislative powers to make? So you mean to say that, as our leading judge just asked, you mean to say that even if they want to change, if they want to introduce new permits, or if they want to produce they want to do new requirements, or to make certain adjustments to tax law, you mean that they can't do that way, just because you have a stabilization clause, so the government can't regulate you at all, or any regulatory change you cannot have? Is that what you're trying to say?
My lord, if I would like to clarify. We're here dealing on the matter of substantive. This is a merit issue. We are saying that what we're arguing is that Gatronia has the right, because of their sovereignty, to enact any law. However, sorry, my lady, has the
Has the right because of the sovereignty. Which sovereignty?
Sorry, my lady, if I'd like to rephrase that, is that due to parliamentary supremacy, the government has the right to enact any law. However, what we are arguing is that any a law can only act retrospectively if it is a matter of procedural requirement. As my lordship has pointed out, if there's any procedural requirement that is being required for an investor to require of merits, and therefore this stabilization clause cannot act. The laws that have been enacted by the defendants cannot act retrospectively.
So those laws, including the Untouchable Terms Act. The Untouchable Terms Act, I thought, put in place a procedure where the National Assembly chooses a contract to review, and then the government negotiating team reviews that contract. Is that not procedural? Is that not a procedural change?
My lady would like to answer as follows: is that the agreement already provides for a matter manner in which we could renegotiate and review our contract. That is per Article 9 of the agreement, and therefore there was no need for the defendants to resort to to enacting new laws while the agreement itself already has a clause for variation, where we could both the claimants, both the plaintiffs and the defendants would be able to mutually agree on how they can variate this contract. May I please proceed? Furthermore, on the issue of enactment of laws, my ladyships and my lord, we agree that the stabilization clause is a valid stabilization clause because it was mutually agreed by the parties where freedom of contract and sanctity of contract, and the principle of sanctity of contract requires that the defendants uphold this stabilization clause. I would like to address the last issue. Yes, my lady.
Because you just said okay, I said maybe I see. Okay.
Thank you. To address my last issue, the last issue is whether the doctrine of permanent sovereignty over natural resources can be invoked by the government of Gatronia. We do agree that countries or states have the inherent right of permanent sovereignty over natural resources, and they can invoke that right. However, my ladyships and my lord, that right that they do have that right that is given to states to deal with the natural resources in any manner that they deem fit does not mean that it gives that state unfettered rights to just be able to repudiate from any contract or to enact any law or to unfairly or illegally expropriate any investment agreement. And we're here to argue, finally, on the issue of doctrine of permanent sovereignty over natural resources is that.
Just a quick question.
Yes, my lady.
So your argument is that the country has contractually vested its rights over natural resources to the plaintiffs.
Sorry, my lady.
So your argument is that the country has contractually done this, and your other argument was that you can't have retrospective legislation. Yeah?
Yes, my lady.
So where I'm slightly confused then, so I understand your point, you're saying go back to 1980 and the laws of 1980, because that's when the contract was implemented. But the laws of 1980, in what way did you have a right to mine in 1980 the land? What was the law saying at that point? Is this contract even valid to give somebody the rights to mine the land? Was this contract enforceable in 1980?
Well, my lady, from the records, from the facts of this case, the plaintiffs and the defendants came together and mutually agreed to have this agreement, and therefore it is valid.
But you want to rely on those previous laws, so you can make an agreement. But is this agreement catered for in law?
Sorry, can you please
repeat? Catered for in law? Is this agreement enforceable?
Yes, my lady, this agreement
and
is.
There was a mining act in 1980. Was there a mining act in 1980?
The facts of the case do not disclose that, my lady.
Was there a mining act in 1980 from knowledge?
Not exactly, my lady. I do not have knowledge of that.
Okay.
I would like to summarize on my issue of permanent sovereignty over natural resources and say that due to the fact that we already have a stabilization clause, which is a valid stabilization clause, so despite of the fact that despite the fact that invocation of the principle of permanent sovereignty of natural resources is valid and is allowed in international law, this does not take away the fact that there was freedom of contract, and this freedom of contract remains intact with the agreement, and therefore they had willingly and voluntarily agreed
Is
to.
there always freedom of contract and sanctity of contract between parties? In this particular scenario, I think the agreed facts are our country has suffered for a long time. We've gone through massive recession.
Yes.
We had our land taken over by people who own your company.
Mhm.
I think those are all agreed facts.
Yes.
And we were on our knees, our education system and everything else. We didn't have the money for expensive lawyers like you people had, because you come and taken our resources and taken them back to your country, to the point where your understanding of the agreed facts is that there were literally more sales of a mineral that only comes in our country outside than there were inside. So in that scenario, is that really sanctity of contract and whether there's such a different bargaining power between the two parties? Is that right?
My lady, if the facts of the case provide that there was, prior to this agreement, the Gatronites were exploited arbitrarily, but the defendants then decided and saw that it was deemed fit to have this agreement with the plaintiffs.
But the defendant was one politician at that point, was one man who went out.
How?
I'm asking you about the principle of sanctity of contract. Does it
Yes.
always apply? And when there is an uneven bargaining power between the parties, is it going to apply?
Well, the defendants relied on the fact that because of the fact that there was exploitation before, they relied on the fact that my client would be able to enter it into this contract and be able to make sure that exploitation of Gatronites is a well-balanced situation, a win-win situation for both.
What circumstances, can I ask this question? What circumstances does sanctity of contract not apply?
Sorry, my lady?
What circumstances does sanctity of contract not apply?
Circumstances where?
So the agreed facts, where there's a very unequal bargaining power, and you have very expensive lawyers, and the defendant didn't have any lawyers at all because they couldn't afford them.
Well, my lady, this agreement was entered into by the president was entered into by the president and the minister and the attorney general, and therefore they are acting on behalf of Gatronians.
Have you signed the agreement?
Sorry?
You signed the agreement?
If the record of the facts served me well, it was the president together with the attorney general and the minister.
Your time is up.
I would like to conclude my arguments and submit my prayers as follows. We do submit
4 minutes.
2 more minutes.
4 minutes.
Thank you. I would like to submit and pray to this court. For the foregoing reasons that we have submitted here, the plaintiffs respectively request the court to adjudge and declare that the matter brought in before this court is admissible, and the court has jurisdiction to hear this matter, and that the second plaintiff that has the locus standi to initiate this suit. Furthermore, to our merits, we submit and pray that the court finds that the acts of Honorable President of Gatronia have amounted to a breach of the Lilo Mining Pact. Furthermore, that the President cannot invoke the doctrines of public trust and parens patriae to stagnate the ongoing mining activities, and also that the newly enacted laws are not applicable to the agreement, and finally, that the doctrine of permanent sovereignty of natural resources cannot be invoked by Gatronian. Thank you.
Just to check with the honourable observers in the back, am I not very loud when I speak? Okay, so thank you very much, counsel for the plaintiffs. Just discussing. So if I may, without further ado, invite counsel for the defendants to please make their case.
Your Lordship and Your Lordship, good afternoon. The one standing before this honorable court is Emmanuel C. Marwa, who is the leading counsel for the defendant, and I'm accompanied by my fellow co-counsel, who is Mr. Noel Adam. Your Lordship and Your Lordship, if it may please this honorable court, allow me to pray that this honorable court adopt our written submission as a part of our oral presentation.